If you could please take your seats, we're just about to start. I'd like to begin by acknowledging the traditional owners of the land on which we meet today, the lands of the Gaddigal people of the Eora Nation. I would like to pay my respects to elders past and present, and all First Nations people joining us today. As the Victorian Parliament has acknowledged, there was a genocide undertaken in this country, and we should all be aware of that when considering the contents of tonight's lectures. I'm Alison Agarwal from the newly formed Association for the Promotion of International Law. We felt that in these deeply troubling times, our collective actions to champion international law have never been more critical. Tonight is part of our first national parliamentary briefing and public lecture series, and we are delighted to be presenting to you two globally significant experts, Chris Sidoti and Emily Crawford. We are privileged to have the Honourable Justice Elizabeth Evatt as our chair tonight, and she'll be introducing our speakers properly soon. Elizabeth is a pioneering figure in human rights law, her career spanning from the first Chief Judge of the Family Court to UN Human Rights Treaty Committees. It's truly remarkable. She needs little introduction, and we are grateful to have her here with us tonight to guide this crucial conversation. The format for tonight will be 2 lectures, followed by a 30-minute Q&A. Please use the QR code on the screens to submit questions from your phones. If you don't have a QR-capable phone, please borrow a neighbour's. And note that despite Elizabeth's concerns about freedom of speech, there's a character limit of 200 words, so you do need to keep your questions brief. Finally, a quick housekeeping note. Restrooms and first aid are in the foyer, and you will be reassured to know that all venue staff are trained first aiders and fire wardens. Now, please join me in welcoming Justice Elizabeth Evatt.
Thank you, Alison, and welcome to everyone on this nice summery evening. This is the third in a series of the Australia International Law and Armed Conflict series. The event has been put together by the newly formed Association for the Promotion of International Law in the effort to increase understanding and awareness about international law, and this is sadly lacking from Australia's media. The event is sponsored by the International Commission of Jurists, Australian section, the Australian National University's Law School, and Amnesty International. Now, it's been heartbreaking to watch the events unfolding in Gaza over the last couple of years and feeling powerless to do anything. This lecture series is about how we can make use of international law to support collective global action. It's a welcome reminder to us that we can contribute to action of some kind, safe in the knowledge that what we're doing is supported by international law. Thus, I welcome our speakers who are going to explain to us how international law applies to the disastrous events in Gaza and other kinds of events of that kind. Now, our first speaker will be Professor Emily Crawford. She's a globally recognised expert in international law at Sydney University Law School, specialising in international, humanitarian and criminal law. In 2023, she was awarded the Max Planck Cambridge Prize for International Law for her outstanding research contributions. The second speaker will be Adjunct Professor Chris Sidoti. He's a leading human rights advocate and legal expert. He served as Australian Human Rights Commissioner from 1995 to 2000. He worked with me some years ago in the Australian Law Reform Commission, and he was the founding director of the Australian Human Rights and Equal Opportunity Commission. Internationally, he was a member of the UN fact-finding mission on Myanmar, and until recently, Chris was a commissioner on the UN inquiry into the occupied Palestinian territory, including East Jerusalem and Israel. They presented their findings in a report in September this year. So now I'll call upon Professor Emily Crawford to open the proceedings.
Thank you, Justice Evatt, for those kind words. Could have saved us time. You could have just said, I'm what happens when you get your Amal Clooney at Aldi. So thank you for inviting me to speak to you tonight about what's been happening in Israel and Gaza the past 2 years. I mean, attention has quite rightly been placed on those acts which have ultimately formed the basis of claims and proceedings in both the International Court of Justice and the International Criminal Court relating to war crimes, crimes against humanity and genocide. But what I want to focus on is more structural, because it's something that actually intersects with our daily lives in a far more quotidian way, which conversely actually gives us more scope to be able to do something about it. I'm going to talk about the increasing roles that corporations play in sustaining armed conflict and what international law and what we can do under the guise of international law to respond. And in particular, I want to draw your attention to, if you had not read it already, Francesca Albanese's July report for the UN, From the Economy of Occupation to the Economy of Genocide. Now, I should note that concerns about the involvement of corporations in armed conflict are not new. Corporations and private commercial actors have long been involved in armed conflict, from profiting from the chaos caused by the armed conflict to providing the material necessary for the execution of the military objectives of the parties involved. And mention of corporate involvement in armed conflict goes as far back as the 1863 Lieber Code that was adopted during the American Civil War. And more recently, the role of paid private actors was the focus of attention following the widespread use of private military and security contractors in Iraq from 2002 onwards through companies like Blackwater, and more recently through the use of the Wagner Group in Africa and against Ukraine. And there is international law on the issue. It's not a completely lawless area. There are rules prohibiting the use of mercenaries in armed conflict, and there are codes of conduct and best practice guides for the use of private military and security contractors. And states are bound by international law in their actions. They cannot contract out their obligations by hiring a private entity to break the law. But where there is a gap in the law, both internationally and to some extent domestically, is when you have situations of corporate involvement in armed conflict, where it doesn't amount to what's known as direct participation in hostilities, or at least in a way that international law understands it. Now, the law of armed conflict, my area of specialisation, is reasonably good, use air quotes there, reasonably good at setting the rules for what happens when someone takes direct part in hostilities. To put it crudely, if you pick up a weapon and fire it, you're considered as taking direct part. You are liable for anything that you do as part of that direct part in hostilities. If you commit a war crime, you can be tried, and you can be tried for the mere act of participating if you are not a member of the armed forces. So there are channels of accountability when it comes to direct participation in hostilities. But the law of armed conflict has very little to say about corporate involvement in armed conflict when it's not so direct, because direct participation is largely about causal proximity to the eventual harm. Fire the weapon, launch the missile, plant the landmine, someone is injured or killed, that's the direct causal link, and that's enough to prove things like war criminality, or at least direct participation if it's otherwise compliant with the law. But step back 1 degree, manufacture the missile, construct the parts of the weapon, and the law of armed conflict generally doesn't consider such participation to be sufficiently causally linked, even though there is that connection. So, for example, a weapons manufacturing plant would be considered a legitimate target in a conflict because it's making a concrete, direct contribution to the hostilities. But the people who work in the plant would still be considered civilians. They would not be considered DPH, they would not be allowed to be lawfully targeted. So that any party to a conflict making a targeting assessment would have to say, well, the plant is targetable, but the people are not. And they would have to then weigh that up in a proportionality assessment. But even more remote and even further removed from the law of armed conflict is when corporations take advantage of and even support an armed conflict for financial benefit. There is no rule in the law of armed conflict that prohibits war profiteering, again, unless it gets to the level of direct participation. And I wanted to set the background for this because tonight I want to go through and do a close read of Francesca Albanese's report, again, just out in July of this year. And I need to make the disclaimer from the international law side of things. Under international law, it is not necessary for there to be a war in order for a genocide to be committed. There is no necessity for a pre-existing armed conflict in order to prove genocide. But as we've seen in Israel and the occupied territories, the armed conflict and the genocide are taking place side by side, notwithstanding the recent ceasefire. And in fact, as Albanese points out, the genocide has been facilitated by the outbreak of the hostilities following the October 7 attacks. So with that legal disclaimer out of the way, I want to delve into her report and analyse some of the key findings and recommendations because it gives us an insight as to what we can potentially do on this side of the planet and even without the kind of power of a government or of the UN behind us. So the core of Albanese's report is in its tracking of the metamorphosis or continuation, if you consider it thus, of Israel's war economy from one of occupation to one of genocide. Essentially, Albanese explores how historically Israel has exploited Palestinian labour and resources, both through the use of land for Israeli enterprises and then through the positioning of the Palestinian people as a captive market for Israeli commerce. So Israel dispossesses Palestinian populations and then they sell that dispossession back to them through, for example, monopolies on water and electricity into the occupied territories. And in her report, Albanese examines how this long-standing system of dispossession and exploitation actually made the atrocities following October 7 possible. They set the groundwork for the crimes against humanity and genocidal acts carried out by the Netanyahu regime after October 7. Because the report highlights how the Israeli government intentionally created Palestinian dependency on its infrastructure for essential resources such as water, electricity and fuel, so that then the subsequent cutting off of these supplies is not merely a military tactic, but an act that can clearly be seen as meeting the legal definition in Article 2 of the Genocide Convention, that of deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. Now, Albanese makes the case that it was and is the deep connection between the infrastructure of the occupied territories and of Israeli control of such infrastructure that made the post-October 7 atrocities so quick to implement, that it was very easy to repurpose infrastructure as a weapon of war and as a tool to violate international law. And Albanese in particular makes this case that the situation in Israel is one that forces us to think more broadly about corporate involvement in armed conflict, which, while it may seem, despair-inducing, actually gives us a window in and an avenue in to try and push back. Now, to contextualise, under international law, there are certain weapons that are prohibited from the get-go. Nuclear weapons, chemical weapons, biological weapons, and certain other types of weapons that are considered to cause unnecessary suffering or superfluous injury. So things like blinding laser weapons or explosives that leave no trace that can be determined by an X-ray. But there are plenty of other weapons that are not prohibited under international law, and a weapons manufacturer like a Lockheed Martin or a Thales could theoretically argue that their very existence is prima facie compliant with international law, that sure, they manufacture weapons, but they don't manufacture weapons that are currently prohibited under international law, and that they don't encourage states to violate international law with their weapons. So therefore, by that reasoning, once the weapon is sold to the state, their connection to what the weapon is being used for is essentially severed. So the argument would go that it's not on Lockheed Martin that a state ends up using the F-35 fighter jet to intentionally bomb civilians and civilian installations. By that reasoning, complicity lies with the state that carries out the act and not the manufacturer that provides the means to carry out such an act. And this kind of reasoning underpins current international law weapons reviews as they exist in treaties like Additional Protocol 1, that a weapon will only be prohibited if by its very nature it is a violation of international law, that by its very nature it is indiscriminate, disproportionate, causes unnecessary suffering or superfluous injury. But a weapon that is not of that nature to carry out that kind of indiscriminate, disproportionate damage or injury is not prima facie illegal. But Albanese's report quite rightly points out that such disclaimers notwithstanding, the situation of corporate involvement in Israel in particular cannot be assessed in a vacuum, that the long-established and well-documented system of oppression and restrictions placed on the occupied territories and the well-established legal principles outlined in the advisory opinion on the wall and the newer advisory opinion on the obligations of third states in the occupied territories makes it impossible for any corporation to engage in any kind of dismissal of causation and proximity to acts taking place in the OPT. That any corporation that sells land-moving equipment like tractors and earth movers to the Israeli government has to know that they are going to be used for the demolition of houses in the West Bank. So what Albanese is arguing for is a broader scope of what constitutes complicity and a greater understanding and appreciation of the heightened human rights due diligence that a wider range of corporate actors must take into account and that we must make them take into account. Now, in her report, Albanese goes through a sector-by-sector analysis, and it's sobering reading because we see how many corporations that we would deal with on a daily basis in the most anodyne way are deeply enmeshed in what is taking place in the occupied territories. So in the realms of technology and surveillance, the report details the deep entanglement of US technology giants with Israel's military and surveillance apparatus. Companies like Microsoft, Google and Amazon provide cloud and AI infrastructure under Israel's $1.2 billion Project Nimbus, and the infrastructure enhances state surveillance and military targeting allegedly housed on Israel-based servers with minimal oversight and has been described by Israeli officials as critical weapons. In the realm of arms and heavy machinery, obviously in addition to companies like Lockheed Martin, the section focuses on the provision of the physical tools of destruction, naming companies such as Caterpillar, Hyundai and Volvo, which have allegedly supplied heavy machinery, including the D9 bulldozer used in the systematic destruction of Palestinian homes, infrastructure and farmland. And that this equipment, though prima facie can be categorised as civilian, has become a militarised tool of destruction, reportedly used for crushing Palestinians to death. And then finally, in terms of financial and investment institutions, the report argues that global financial actors are central enablers of the settler colonial project, that major insurers and investors like Allianz and AXA are named for their extensive investments in companies linked to the occupation. Now, in framing her report, Albanese points first to the UN Guiding Principles on Business and Human Rights as a normative guide. Now, they're not binding, and that should in its first instance tell you how little we've got to go on when it comes to this kind of involvement in armed conflict and in violations of human rights. International law is a system that was set up to guide the behaviour of states, of sovereign nations, has been rapidly, but in some cases not as rapidly, catching up to try and hold non-state entities accountable. So the wealth of human rights law is designed to protect individuals, but there is still that gap when it comes to regulating the acts of entities that are neither individuals like us, legal people, or states. So legal entities like corporations are still, in many respects, falling through the gaps in international law. But the UN Guiding Principles are a well-accepted document that places obligations on corporations and obliges them to identify, prevent and mitigate risks of their activities contributing to human rights abuses. And the framework places a responsibility on corporations not just to avoid causing harm directly, but to prevent their activities from being directly linked with or contributing to adverse human rights impacts. But Albanese goes further, and in this respect she employs a principle from international criminal law known as joint criminal enterprise. And she argues that corporate involvement is not just a passive act, but it's actually an active collaboration. And in this framework, the acts of a single actor, such as a corporation, supplying a piece of equipment, contributes to the larger system of alleged international crimes. And so by this legal interpretation, corporations are active participants rather than mere bystanders. And there is actually legal precedent for this. Lawyers love a precedent, and in this case we have one. We have one from the Nuremberg trials that took place after the end of the Second World War, specifically the prosecution of IG Farben, the German industrial conglomerate that was the largest industrial supporter of the Nazi regime, and which in the aftermath of the war was prosecuted for having manufactured and supplied Zyklon B to Nazi death camps. And in that case, one of the three against German industrialists, including the Flick and the Krupp trials, the Allied Control Council held both the individual executives and the corporate entity accountable and ordered the company's dissolution. So there is hope that we might be able to use that as a lever. Now, the report concludes with a series of recommendations intended to dismantle the economy of genocide, and the most prominent of these is a call for a comprehensive two-way arms embargo on Israel. So it's not enough to stop selling arms to Israel, you've got to stop buying from them too. And the recommendation goes beyond the actions of countries that have only just suspended arms sales, instead calling on a ban for arms exports to and imports from Israel. And it's framed not just as a policy choice, but as a legal and moral obligation under international law to prevent genocide. In addition, Albanese urges states and companies to promptly cease all business activities and terminate relationships that contribute to human rights violations and international crimes. She calls for sanctions and a full arms embargo with the goal of isolating Israel economically. And the report further demands that national and international legal institutions investigate and prosecute corporate executives and entities implicated in international crimes. The Economy of Genocide report, authored by Francesca Albanese, is a landmark document that has had a profound impact. It has successfully centred the issue of corporate complicity in international discourse, forcing companies to address their roles and galvanising public opinion and activist movements like boycott, divestment, sanctions. It does present a significant point of entry as well for lay people to engage in a meaningful way in what's taking place. While we can't always easily prevent our national government from signing bilateral investment treaties or from contracting with weapons manufacturers, we can boycott firms who continue to invest in regimes that clearly breach international law. We can vote with our wallets as well as our ballots. Thank you.
Thank you very much, Emily, for that enlightening talk. I'll now call on Adjunct Professor Chris Sidoti to talk to us.
Thank you, Elizabeth. You know, Elizabeth is the real superstar here tonight. Emily and I do interesting things, but Elizabeth is the one who's done it all. So it's wonderful to be sharing a platform with you. I need to start with an acknowledgement and an apology. The acknowledgement is to the Aora people of the Aora people of the Gaddigal Nation, who are the traditional custodians of this land, who have kept it in the beautiful form that we can now enjoy. And I thank them for that. And I take particular pride in the fact I'm not Indigenous, but I'm a lawyer. And this land still sees the oldest continuous legal system on the faces of the planet. And any Australian lawyer, of whatever the background, should be proud to be the inheritor of that ancient legal system. And the apology is that... Sorry. The apology is to any of you who might have heard me over the last few weeks, because much of what I'm going to say tonight is the same old thing yet again. But I'm perhaps saying it in a bit more detail tonight, and so I hope it's not totally boring. But honestly, feel very comfortable falling asleep. Perfectly okay. I'm not going to call you out. In Alison and Elizabeth's introductions, they referred to this new Association for the Promotion of International Law, and I'm very pleased to see Paul sitting up the back, who has been the unguided missile who has actually driven this whole process. I'm pleased to see this new attention to international law because it is so important. The great Gareth Evans, when he was Foreign Minister, whatever that is now, 30 years ago, used to talk about Australia being a good international citizen. And for me, that is still a fantastic concept, a great phrase, a good international citizen. And a good international citizen is one that respects and complies with international law. That's the simplest definition that I can offer. I'm not an eminent, internationally renowned international law scholar like Emily is. I'm an international law practitioner. And in being a practitioner now as a human rights lawyer for 40 years, the basis of my work at all times has been international law. I mean, that was the case right back in the beginning when I was working at the Australian Human Rights Commission, eventually Australian Human Rights Commissioner there. We then, and we still, have no National Bill of Rights in this country. We have no legal standard against which the laws, policies, practices, programs of government can be measured. And so our human rights legislation has its basis not in our constitution, which is almost silent on the subject. It has its basis in international law. And the legislation that governs the Australian Human Rights Commission and the legislation dealing with race discrimination, sex discrimination, disability discrimination, age discrimination, all of the freedoms of civil and political and economic, social and cultural rights, all of this derives from international law. And that has been the only basis upon which I have been able to be a human rights advocate in this country for the last 40 years. When I was working for international non-government organisations in Geneva, it was international law that was the basis of the advocacy. When, as Elizabeth referred to, I was on the UN fact-finding mission on Myanmar, and later the Commission of Inquiry on Palestine and Israel, international law has been the basis of that work. So for me, international law is the bread and butter. It's the solid foundation upon which my work has been built. But more than that, it's not about me. It's about good international citizenship. And that's why it's important tonight. That's why it's important to have this new association talking about promoting international law. Because surely we want to be, as Australians, a good international citizen. Emily spoke in her comments about the private sector, business, and built it very much on Francesca Albanese's report from June, not to be confused with another Albanese who doesn't speak very much about these issues. I want to talk about not the private sector, but about state responsibility. And I want to talk about not the responsibilities of the states most directly involved, that is Israel and Palestine, but of the other 192 states in the world, referred to in international law as third states. The first two states, Israel, Palestine, are the combatants. Everybody else is a third state. And my comments tonight will focus on Australia's obligations as a third state under international law to be a good international citizen. The Commission of Inquiry on Israel and Palestine was established 4 years ago, and I was a commissioner on that up until early November. We were established before the events of 7 October 2023, 2 years before those events. Our own history reflects the fact that this conflict didn't start on the 7th of October 2023. We were established in May 2021 after the previous explosion of violence. An explosion of violence like that of 7 October, and since then, that was part of a 100-year war that has been going on in the territory that is now Israel and Palestine. A 100 years war in which the context is extremely important to understand all that has happened and all that is happening. So we came out of the May 2021 fighting. We started our work immediately and we produced a number of reports in 2022 and 2023. We had only, at the end of September that year, 2023, adopted a 3-year work program when a week later we had to ditch it because 7 October came and we had a pretty fair idea of what was going to follow. We were wrong. We were totally wrong. We were expecting an unmitigated disaster to unfold in Gaza and to go for 6 weeks. That was the standard period of fighting in past explosions of violence. I don't think anybody could have expected that 2 years later we are still seeing what we are seeing in Gaza. By the end of this year, or by now, our Commission has produced 8 reports, 8 formal reports to the General Assembly and the Human Rights Council, 5 supplementary reports, 2 legal advisory papers, so 15 reports in all. The last of which was the report on genocide that we released in September this year. Our reports made findings of war crimes and crimes against humanity from the very beginning. When we started looking at what happens on the West Bank, we could not conclude that it was other than war crimes and crimes against humanity. And that was before the 7th of October. But particularly since then, there is no doubt in our minds that we have seen war crimes and crimes against humanity committed. And then, as I indicated, September this year, we dealt with the situation in terms of the law of genocide. It took us 2 years of intensive investigation into the events in Gaza before we came to that conclusion. Many eminent people, organisations, experts came to the conclusion well before we did. It took us so long because we are in an investigative body. We conduct our own investigations ourselves. And during those 2 years, we looked one after the other at different aspects of the situation in Gaza. So we examined the concerted destruction of health, including infrastructure and personnel, the concerted destruction of the education system, including infrastructure and personnel, the killings of humanitarian workers, the sex and gender-based violence that was occurring against Palestinian detainees and Palestinian prisoners. We looked at the impact on children, and in fact, I hope that there will be a report just on that subject next March that is released. We examined housing and the clearance of land. We looked at the policy of mass starvation, and so on. Our reports took each of these issues separately. They reported the results of our investigations. They helped us to build the full picture. Our methodology is the standard legal methodology. We collect evidence. We form conclusions as to facts on the basis of the evidence. We apply the law to the evidence and to the conclusions of fact. And we form conclusions of law. Nothing particularly dramatic there. That's how we work. The crime of genocide is a more difficult crime to prove than war crimes and crimes against humanity. That's why there are so few findings of genocide in international conflicts. War crimes are essentially individual acts. An individual committing a war crime, breaching international law of war in a situation of conflict. Crimes against humanity goes one step further in complexity. The acts must be widespread and systematic. So it starts to become necessary to look at how broad the activities are that constitute a crime against humanity. But genocide requires a more comprehensive picture again. It really needs to look at the totality of the circumstances. And so our approach of putting together the pieces of the picture and doing that comprehensively before we were able to come to a conclusion on the subject. I need to say a bit about the nature of the crime of genocide in law, because the legal understanding of genocide is very different, it seems to me, from the popular understanding. And that makes our job as lawyers a very challenging one. I think people have this vision that genocide is any mass killing and that it can only be constituted by a mass killing. You know, the archetypal genocide was the Holocaust during World War II, but there have been others before and since. And I think this popular understanding of mass killing equals genocide is understandable, but it's not what the law says. And as lawyers operating in a legal institution with our Commission of Inquiry, we have to apply the law and not popular understandings. The crime of genocide is defined in the Genocide Convention, in the Rome Statute of the International Criminal Court, and it's also defined in international customary law. It applies to all states. It's a crime that is of universal application, which generates universal obligations on states. The crime has to be committed against a group that is defined on the basis of race, ethnicity, nationality, or religion. Those four bases only. So the mass killing on political grounds or socio-economic grounds socio-economic grounds, levels of education, these do not constitute genocide under the law, even if the killings are mass killings in those circumstances. It has to be defined, this group, by race, ethnicity, nationality, or religion. So in looking at the crimes of the Khmer Rouge in Cambodia, this distinction becomes very sharp. The Khmer Rouge's killing of 1 or 2 million Cambodians, a huge number of people in the space of 3 years, was not genocide because it was not defined by race, ethnicity, nationality or religion. They killed the educated, they killed the rich, they killed those who owned land, so the farmers, those who owned businesses. They were the principal targets until everybody was targeted. But there were some ethnic minorities in Cambodia, such as the ethnic Vietnamese and some hill tribe people who were explicitly targeted on the basis of their ethnicity. And the courts have found that that was genocide. So we have the strange situation where the killings of relatively smaller numbers of people in the Cambodian context constituted the crime of genocide, while the killing of the great mass of Cambodians did not. But that's what the law says. So for us, you know, we apply the law. The International Court of Justice has said that the Palestinian people constitutes a group that is entitled to the protection of the Genocide Convention. So the question of group does not arise as a legally open question anymore. The International Court of Justice has said this on several occasions now, and it's a closed issue. Like all crimes, the crime of genocide has two dimensions: an act and an intent. We know that under our law here. You know, any crime involves doing a wrongful act with the necessary intent. The definition of genocide specifies 5 categories of wrongful act. And these categories exist independently of each other. You don't have to meet all 5 or 3 out of 5, only 1 out of the 5. So the 5 categories are killing members of the group, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction, in whole or in part, imposing measures intended to prevent births within the group, and forcibly transferring children of the group to another group. We found that 4 of those categories of genocidal act had arisen in relation to the campaign in Gaza. The one that was excluded was forcibly transferring children of the group to another group. There was no evidence of that. Can I just make a comment as an aside? The Gaza situation is the 3rd time in my professional life that I've had to consider the issue of genocide. The first time was when I was the Australian Human Rights Commissioner, and the Commission was undertaking its national inquiry into the separation of Indigenous children from their families. The Bringing Them Home inquiry. That was led by Ron Wilson and Mick Dodson, but all of the commissioners were involved, and I was involved in that. And we found that the removal of children from Indigenous communities to non-Indigenous communities was the 5th category of genocidal act. And we then found that the necessary intent had occurred as well. So we found genocide in the policies of the removal of children. And the then Prime Minister, John Howard, went off his ever-loving brain. And he said, "But no one was killed. You have not found a single death." And the answer is correct. I mean, people were killed, but we didn't examine deaths, we examined separation. And this is one of the 5 freestanding categories of act of genocide. But it didn't meet the Prime Minister's and his government's expectations. And they cut the Commission's budget by 40%. There are 2 issues of intent with genocide, and again, this is the other level of complexity. There must be the standard intent to do the act. That's fairly straightforward. But there must also be a specific intent to do the act for a genocidal purpose, and that is to destroy the group as such, in whole or in part. And I emphasise those last words, in whole or in part. It is not necessary under the Genocide Convention to intend to wipe out every Palestinian in the world. Carrying out the conduct, the 4 categories of act, with the intention of destroying the Palestinians as a group in part is sufficient to meet the definition. And so when we hear Netanyahu say, "Oh, it couldn't possibly be genocide because if we were going to commit genocide, we could kill them all tomorrow." He said that. Doesn't make any difference to the definition of genocide under the Genocide Convention. So they're the factors. And in our work, we found that genocide had been committed. We did so on the basis of our own investigations that were reported one after the other between June 2024 and June 2025. We did so on the basis of the facts that we had found, and we did so on the basis of the application of the law, the well-accepted law governing genocide. Our investigations focused on perpetrators, both states and individuals. But our investigations and our reports have direct implications for third states. And that's the focus of the last of my comments, the main part, I think. These obligations on third states arise again under international law. They can be obligations to take action, positive obligations, or to refrain from action, negative obligations. And the obligations arise under the Genocide Convention and under the Geneva Conventions as well that govern the law of war or the conduct of armed conflict. The Genocide Convention in Article 1 says that genocide, whether committed in time of peace or in time of war, is a crime under international law which states undertake to prevent and to punish. So the obligation under the Convention is not only not to commit genocide, it's also the obligation to prevent and the obligation to punish. Prevent occurs before the fact. It is prospective. It arises where there is a reasonable risk that genocide will occur. And it continues while genocide is occurring. So it doesn't require any determination that there has been genocide. All it requires is a reasonable risk. Punish, of course, is retrospective. You can't punish until the crime has been committed, although you can punish incitement. So those obligations exist. And under the Geneva Conventions, there's an obligation not only for states to respect the laws of armed conflict, but also to ensure that other states respect the laws of armed conflict. So we have obligations under the Geneva Conventions as a third state, even if we're not involved in the hostilities ourselves. We have obligations to act to ensure, in this case, that Israel and Palestine respect the Geneva Conventions and their obligations under them. There are also obligations that arise under the decisions of international courts. And here the decision of the International Court of Justice last year, dealing with the continuation of the Israeli occupation, was a really important decision. And you know, I can do some back-patting at the moment. That decision came about because of our commission. We'd produced a report in 2022 where we said, having examined the facts and applied the law, that the Israeli occupation was unlawful, that the Israeli settlements were unlawful, that the occupation had to end and the settlements should be withdrawn. But we said, you know, we're just a mere commission. The most authoritative decision possible is a decision of the International Court of Justice. And we recommended to the General Assembly that it seek an opinion from the court on this question. And to my utter amazement, the General Assembly did that within 6 weeks. And the decision that the court handed down last year was a result of the General Assembly decision which came out of our recommendation. And the court found exactly what we had found, that the occupation was unlawful, that the settlements were unlawful, that there should be no further settlements, that the existing settlements should be evacuated, that all settlers should be withdrawn, and that reparations should be made to the Palestinian victims of these unlawful activities. The court went further and spoke specifically about the responsibilities of third states under these circumstances. And the court said that third states have an obligation under international law not to aid or assist the continuation of Israel's unlawful acts in any way. Not to aid or assist in any way. And the court didn't give very specific indications, but it did refer to the categories of relationship that needed to be examined. Political and diplomatic, economic and financial, military related, culture, quite a wide range of areas that needed to be examined. So the obligations are there. They've been identified by the International Court of Justice. They're contained within the treaties with which we are a party, and we should be acting. We should have acted. The situation in Gaza and the West Bank at the moment does not really alter the legal analysis that I've given you. There is largely a ceasefire at the moment. We can't say that it is a full ceasefire or an effective ceasefire. Palestinians in Gaza are still being killed. The numbers are far less than they were, but there is a ceasefire. But that's not the end of it. You know, that's not the end of it. I mean, the first thing that can be said is that an end to the fighting doesn't wipe away the sins. The criminality is not affected by the fact that there may be a peace agreement, which there's not anyway. It's not affected by the fact that there may be a ceasefire, or even that some of the criminal activities may have come to an end. So we can't simply say that the fighting's largely stopped, peace has broken out, isn't this wonderful, we don't have any responsibilities anymore. No. We have continuing responsibilities that I have already outlined for you under international law. And the fact that 3 issues have been or are being addressed is good. You know, the fact that the killing has largely stopped is good. I don't in any way argue against a total ceasefire. I just wish it was total. The fact that the Israeli hostages have been released, living or dead, there are still 2 bodies left, is good. We said on the 10th of October 2023 that the taking of hostages was a war crime and the holding of hostages was a war crime. They were entitled to be released, and it is good that they have been released, and it's good that largely Palestinian arbitrarily detained individuals, detained contrary to international human rights law, but also some Palestinian prisoners have been released. This is good. The fact that there is more humanitarian aid getting in, although still far less than what had been agreed, it would appear, I'm having trouble getting the stats, but it would appear that the amount of humanitarian aid getting into Gaza at the moment is about 1/3 of what was agreed. That's good. Not good enough. But these developments don't alter our international obligations. That's what I'm saying. They don't alter them. And we still have these obligations to act to prevent genocide, to ensure respect for the Geneva Conventions, not to aid and assist the continuation of Israel's unlawful occupation and settlements in any way. Australia has already done some good things. And I'm very pleased about it, and I thank the Australian government for having done it. It's good that we have prohibited the export of weapons, as narrowly defined as that has been. It's good that we've imposed sanctions on 2 Israeli ministers, Ben-Gvir and Smotrich, and some criminal settler leaders. It's good that we've changed our voting pattern in the General Assembly. It's good that we've recognised the state of Palestine. All of these things are good, but they're hardly sufficient. They hardly could be described as an adequate response to Australia's obligations under international law. We hear that we're not doing other things. It's been said by the Prime Minister and the Foreign Minister, because we're a long way away and we're a small state and we can't be all that effective. I'm not a politician, I can't make those assessments. But, you know, I'm a lawyer, and it's the wrong question. You know, as a lawyer, the question is, what are our legal obligations and what do they require us to do? It's not how far away we are or what size we are. the real question, the right question, is what are our legal obligations? Now, Trump produced his 20-point thought bubble. Only 3 of the 20 points were agreed. They've now been somehow endorsed by the Security Council in part, but really it's still a thought bubble. I want to give you mine. I want to give you my 20-point thought bubble on steps that should be taken by the Australian government in fulfilment of its international obligations. 1, undertake a comprehensive review of all Australian relationships or aspects, connections, dealings with the State of Israel, to identify those aspects that render aid or assistance in maintaining Israel's unlawful actions in the occupied territories, and cease those aspects of the relationships that do aid and assist the continuation of the occupation. Now, that should have been done last July, when the International Court of Justice said that all states have got to do this. And maybe it was done on a top secret basis. I'd like to see it released. My suspicion is that it wasn't done, because every time I ask, was it done, I just get, the rolled eyes. 1. 2, end all political and diplomatic contacts, such as official visits and exchanges and state receptions. This is part of what the International Court of Justice referred to as political and diplomatic relationships. 3, cease all military-related trade between Australia and Israel. It's not good enough just to ban the export of weapons. We need to look at two-way trade, exports and imports, and we need to look at anything that is military-related. So not just the weapons themselves, which we have banned, but components made in Australia for F-35 jets that are dropping very big bombs on Gaza and have been since the 7th of October 2023. Other materials that can be used in the construction of weapons, like steel that could be used in tanks. Dual-use items that can have civilian or military purposes. And also the imports of those from Israel. The Israeli defence company Elbit, private company, is the largest Israeli arms manufacturer. It produces fantastic drones. It also produces some of the most advanced surveillance technology in the world. Our state police forces really like advanced surveillance technology. We should not only be banning export of Australian arms to Israel, but the import from Israel of anything that adds to the profitability of the Israeli arms industry, or even worse, contributes to Israeli research and development of weapons and surveillance technology that can be used against Palestinians. 4, we should cease all military and trade promotions, such as sponsoring or partnering trade exhibitions that include Israeli armaments companies. 5, we should close the Australian Defence and Trade Office in Jerusalem. This office was established a few years ago. Its intention was to promote defence and trade links. Can you imagine us having an office to promote defence links with the Israeli military? I've got to put a caveat on this one. I heard a rumour a couple of days ago that it may have been quietly closed and the Australian government's not telling anybody. I've been trying to check that out, and I hope I'll get an answer. So let me change this point by saying, if it has not already been closed, then close the Australian Defence and Trade Office in Jerusalem. 6, withdraw all defence and trade officials from the Australian Embassy in Tel Aviv. I'm not suggesting close the embassy or withdraw the ambassador. On the contrary, I'm saying 7, upgrade the Australian Representative Office to Palestine to a full embassy, so that we have equality of diplomatic representation to Israel and Palestine. 8, publicly affirm, in accordance with our obligations under the Rome Statute of the International Criminal Court, that we will carry out any arrest warrants issued by that court including those relating to Netanyahu and Gallant, and any others who may be subject to arrest warrants relating to the violence on and since 7 October. 9, impose further personal sanctions against individuals in political and military leadership roles in Israel. 10, impose further personal sanctions against criminal Israeli settlers responsible for the violence in the West Bank that has reached unprecedented levels. 11, investigate and, where the evidence warrants it, prosecute Australian citizens who have served in the Israeli Defence Forces since 7 October for crimes against humanity or war crimes or the crime of genocide. 12, change the law to prohibit Australian citizens from fighting in the armed forces of foreign states. 13, prohibit financial transactions with Israeli settlements and with Israeli organisations that support the establishment or maintenance of settlements. 14, end tax deductibility for any Australian charities that provide funding for Israeli settlements or for Israeli organisations that support the establishment and maintenance of settlements. 15, impose secondary sanctions on states that conduct arms trading with the State of Israel. 16, provide at least 15,000 humanitarian places for permanent settlement in Australia from Palestinian refugees who may want to come here. 17, press the State of Israel to make reparations to the State of Palestine for the destruction of the Gaza Strip and contribute ourselves to reconstruction efforts. 18, a small point but important to me, restore scholarship eligibility to enable Palestinians to undertake tertiary studies in Australia. For reasons that I have been unable to determine, Palestine was dropped off the list of eligible countries for Australia Awards tertiary scholarships in about 2021 or 2022. When every university in Gaza has been destroyed, Palestinian kids have got to come here so that we can contribute not only to their future, but to the future of Palestine. 19. I promised you 20 points. I'm going to leave 19 and 20 to you. We are an exceptionally creative people. So you give me, use this thingo, you give me 19 and 20. But we've got to have 20 because if Trump can have a 20-point thought bubble. In Melbourne last week, my 20-point thought bubble was transformed into a 30-point thought bubble or more. That's why Trump had to have 28 points for Ukraine. He heard about it. So let's look at what we can expect Australia to do to meet its international obligations. Yes, I'm finished. What I've been talking about is not a question of politics. I'm not a politician. It's not a question of ethics. I'm not an ethicist. It's simply a question of law. And a question about whether we, as Australians, want this country to be a good international citizen.
Well, thank you very much, Chris Sidoti. You've thrown out a challenge to everyone. Now the challenge is with me. I have been given a training session how to use this new way of putting questions, and I hope I can do it, but please be patient. I'm a slow learner. Let's get on with it now. Question time.
Gotta use the microphone.
Sorry. The first question, what are government's responsibilities to prosecute returning citizens who have committed war crimes in armed conflict? I think I'll throw that to you, Chris.
I need say very little more. The responsibility is to investigate, and only if the investigation produces evidence to warrant prosecution is there a responsibility to prosecute. But my comment is that given the amount that our Commission has found about the events in Gaza over the last 2 years, anyone who comes to Australia having served in Gaza in the Israeli Defence Forces over the last 2 years must be considered a person of interest. It's as simple as that. And
Emily, do you want to add to that?
No, Chris has answered it very well. Basically, there is an obligation on states to, if they find someone in their territory who is suspected to have committed war crimes, crimes against humanity or genocide, they have an obligation to investigate if there are grounds to prosecute, and if they are unable or unwilling to prosecute, if another state can make out a case, they are under an obligation to extradite. It's known as universal jurisdiction.
Okay. Next question. Can you explain how are governments held accountable for their breaches of international law? No one seems to be held to account. Emily, would you like to try that?
Oh, so give me the easy one. Awesome. Okay. All right. So when you're a student of international law, it is very easy to become disillusioned because you do see circumstances of states seeming to breach the law and getting away with it. The thing that I would tell you is that while some of the breaches of international law are catastrophic and it does seem that states get away with it, I would reassure you that the thriving docket at the International Court of Justice is manifest examples of states breaching international law and not getting away with it. And Australia has been involved in that in cases. So, for example, with the certain phosphate mining in Nauru. Nauru took Australia to the ICJ for its failure to treat its trusteeship over Nauru properly and basically strip mine it for phosphate. Nauru won, Australia paid reparations. So there are manifold cases of states being held accountable in the International Court of Justice, in arbitration tribunals, in the International Tribunal for the Law of the Sea. But like any court system, there will be people who aren't held accountable. Unfortunately, that is the nature of a legal system just generally, but even more so in a situation like international law, where you are reliant on essentially states committing to the process. And there will be states who don't commit to the process.
So, next question. What is your comment on the UK Starmer government, supposedly of social democratic heritage, proscribing the civil protest group Palestine Action under terrorism acts alongside Al-Qaeda or ISIS?
You can
Chris,
have this
you
one,
want to
Chris.
go, or Emily? Who's going?
the person who should answer this one is not here tonight, but the third person who often speaks with Emily and me, who's Ben Saul.
Oh, Ben Saul.
Ben is professor at Sydney Uni as well. He's the UN Special Rapporteur on Human Rights while countering terrorism. Look, I'm going to duck out of this one for a very good reason, because there is no internationally accepted definition of terrorism. And I refuse to throw around the word terrorism, and I hate seeing governments throw around the word terrorism when it is not a term for which we have a universally accepted definition in law. So I would answer that question in another way by saying that the whole concept of terrorist acts is one that I do not understand. If they have been doing something criminal, and presumably entering a military base and defacing aircraft were criminal actions, the criminal law is enough, surely.
Yeah. Do you want to add anything, Emily? No? Okay. Then we'll come to the next one. Oh, Mark has answered. How can we force super funds and charities breaching international law by investing in companies, groups directly complicit in the occupation to divest by using the law rather than just public pressure? Emily, this is for you, I think.
So I'm not going to be able to answer that completely well, simply because I'm not a specialist in either domestic tort or contract law, so I don't know the domestic avenues that you would be able to bring against a super fund, against a charity for engaging in those activities. I work with a lot of people who are tort and contract specialists. If you give me 5 minutes, I can give them a call and put them on the spot. But I would counsel to not rule out public pressure as a very important lever. So I'll give you an example. I work at Sydney Uni. Today we got a message from the Chancellor letting all of the employees know that this is public, this is not... Oh, I really hope it's not private news. Cone of silence. No, saying that the university is in its latter stages of its divestment examination. It is going to start divesting from military firms. And I don't think you can say that is as a result of anything other than the encampment that took place at Sydney University last year.
Okay, so next. What role are the bases, including Pine Gap, playing in perpetuating the genocide, and should their role in providing targets in Gaza be prohibited by Australia as the sovereign host? Chris?
For this one, I have to answer at a level of generality because I have not looked specifically at the role that Pine Gap has played. The second part of the question assumes the answer to the first. The second part says that it's providing targets in Gaza. I don't know that that's the case or not, but I do know that Pine Gap is a surveillance station. But my general answer again has to go back to the law, and that is we should be acting to prevent genocide, not to facilitate it. We should be acting to ensure respect for the Geneva Conventions, not to support breaching of them. And it's quite clear to me that if Australian military bases of any kind, including Pine Gap, are assisting in the commission of international crimes, then they shouldn't be. They should be stopped. It's a breach of international law. And the government needs to be held accountable for breaching international law because of the activity of the bases. But I can only answer at that general level, I'm afraid, because I don't have the specific knowledge.
Okay. So, what can a state government do to fulfil their obligations regarding genocide? And in particular, can they regulate corporate behaviour? Who would like to go on that, Emily?
So the benefit of corporations law is that corporations, in order to be considered legal persons and therefore have the rights to sue and be protected under domestic law, they are required to register in a particular country. They're required to incorporate. And so it's entirely possible for the sovereign state in question to impose restrictions on a state before they're allowed to, on a company before they're allowed to incorporate. To basically say, okay, fine, if you're going to incorporate in our country, here are the rules you have to follow. You breach those rules, we'll strip you of your legal status. The difficulty comes, of course, with really powerful multinationals who have, offices all around the world, but also from multinationals who set up in basically countries of convenience because they take advantage of the fact that there are not particularly strict corporate responsibility rules. But in countries like Australia, there are increasing rules with regards to corporate responsibility and corporate due diligence. There are colleagues at Sydney Uni who are doing a huge amount of research on human rights obligations of corporations and working with the UN to try and increase that kind of accountability.
Okay.
And can I just talk about the state government part of the question for a minute? That in international law, Australia is taken as a single entity. We are the international actor. And international law doesn't distinguish between federal states and the federal components. Collectively, we have obligations. So state governments, state parliaments do have obligations under international law. They share in the obligations of the nation as a whole. And many of the points in my 20-point thought bubble have direct implication to the states. State sponsorship of an arms exhibition in which Elbit and Raphael are exhibiting. Are our police purchasing surveillance technology or drones from Elbit? What are the broader procurement policies that the state government has in relation to non-trade or non-procurement of goods coming out of Israel that have military-related purposes? Official visits and delegations. You know, you can go through the 20 points and a lot of them relate to the state government as well.
Okay, I'm putting them up a bit too early now, but the next one is, given sufficient support, might it be possible to bring a class action in order to oblige the Australian government to comply with its international agreements, treaties and conventions? That's a bit of a tricky one. Emily, what do you think?
Yeah, okay. So the difficulty is that under the Australian Constitution, the government has basically unfettered rights in terms of under what's known as the external affairs power. So it's entitled to contract, engage in treaties on whatever ground, so long as it relates to something external to Australia. So you would have to find basically a cause of action, and again, this is FedCon, which I nearly failed when I went through law school. So you would have to basically find a cause of action, am I right, in the Constitution to be able to say, or elsewhere to say that you can basically hold the government to account, and unless it related to like an administrative law decision, it would be hard, I imagine.
Yeah. You agree?
Can I just perhaps add that as a general proposition, might it be possible? No. As a specific proposition, perhaps. Because Australian law requires the treaties be incorporated into our law by legislation to be enforceable here. And in most instances, Australia doesn't incorporate treaties as a whole. And so as a general proposition, you can't enforce a treaty. But elements of treaties can find their way into different parts of law. And if you can find a hook to hang it on, you can move under a different aspect of the law where a treaty is specific. And, the example of that is, as I said before, the Human Rights Commission's legislation. That's all based on treaties.
Yes. I think the courts are a little bit more open these days to consider these kinds of obligations and how they might relate to a particular case. Not exactly to enforce it directly, but to ensure that decisions that are made are more or less in compliance. It's not quite what's asked for, but it's a step. Okay, let's go now. Oh, this is an equally difficult one. Some international law experts are advocating for invocation of Resolution 377A Uniting for Peace as an effective way to stop the genocide. Would you agree with that or provide an alternative? Oh dear, who's going to do Resolution 377A? Is that you, Chris?
This is a nightmare question. Resolution 377A is a resolution of the General Assembly adopted in 1950. It has been applied once in 1956. It was put up by the Americans, funny enough, to deal with the Korean War when the Security Council was deadlocked. And it's meant to give the General Assembly the capacity to do things when the Security Council can't act. I suspect that the Security Council's resolution last week eliminated any prospect of 377A being used because, however inadequately, the Security Council resolution does indicate the Security Council has acted. So maybe the General Assembly is not able to invoke 377A now, but it's, as I said, it's been used once in 80 years. It's not particularly effective. It would be highly political, and I don't know that it has been... It's been seriously suggested by a lot of civil society groups, I'm not aware of any state whatsoever that has suggested using 377A to deal with Gaza at the moment.
Okay. I've got to mark that as read now. Well, the next one, I think we've more or less dealt with this. Can Australian citizens take legal action against Australian businesses, whose business activities support Israeli illegal settlements or genocide in Gaza? We didn't quite deal with that. Someone want to deal with that?
Yeah, anyone in the audience want to deal with that one? Yeah, again, you would have to basically find that there is a domestic cause of action that allows you to act, which, again, is delving into the domestic law side of things, which, can you guess, I'm not an expert on. And look, the other thing I would say is, as much as legal action is the appealing answer to everything, courts are expensive and take time. And they are bound by really, really strict rules on things like evidence, which can sometimes be, if you've got a good enough lawyer, can be construed against you and against your case. And so, as much as my entire career ends tomorrow if the law disappears, it is not the only tool in the toolbox, and probably shouldn't even be considered the first one. For something like this, you've got much more power to actually, do things like boycott and cause a ruckus and things like that. I think we can safely say I don't know that, Sydney University would have divested from things like, what does my brain not work? Don't answer that question. No, just all the stuff that Sydney's divested from climate change, fossil fuel, armaments from fossil fuel companies and things like that. None of that would have happened if there hadn't actually been pressure. And it's much quicker and easier to do than trying to navigate the Australian legal system.
And just a comment that doesn't answer the question. Norway has the largest sovereign wealth fund in the world. And Norway has a state-of-the-art ethics process about their investment. It's not perfect, but it's pretty damn good. We are so far behind. Even if you look at the bloody Future Fund, which is happy to invest in Elbit, I can't believe that. We got a long way to go. And taking Emily's points and looking at this question, we've got to improve the ethical control over the investment policies of both state and private sector companies, investment funds, superannuation, Future Fund, because we're a long way behind.
Okay. Well, now we're getting close to the end now, so this will be, I think, the last question. What reforms are needed to ensure that international law mechanisms are activated on an international and state level, such that action is timely in saving lives and is done so in a consistent manner? Well, that would resolve everything, wouldn't it? If we could do it.
Okay, so the utopian ideal is reform the Security Council. Basically, that would be the starting point, to either find some way to remove or counteract the veto, because that's been the biggest hindrance. I mean, Chris referred to the stalemate in the Security Council, which lasted the length of the Cold War. Because there were just those ideological lines. Even if people didn't agree with them, there was just an ideological line of the Russians were always going to oppose the US, China was always going to side with the Russians, even if they happened to agree on something. So step one would be reform the Security Council, amend or get rid of the veto. The problem, however, is the UN is, as lots of experts are pointing out, at a bit of an existential crisis. There's a colleague who works, who used to work at the UN, who now is at Sydney Uni, talks about the fact that friends of his back in New York are openly planning for the move. They're openly planning for when Trump kicks the UN out of New York, and where they will relocate and if they'll survive. If the UN as we know it will survive, which is terrifying for something that's been such a feature of international legal life for 80 years. But the difficulty, of course, with reforming the Security Council is that you have to get the P5 to agree to reform the Security Council. It's getting the fox to investigate the hen house. I don't know what would be the reforms beyond the stuff that we're unfortunately in too much of a deadlock to fix.
Wouldn't it be just wonderful if we followed the example of some states and made treaties part of our law once they were fully ratified, you know? I think there's still a few states that do that, but not.
And it's not impossible.
Australia.
Yeah, and it's also not impossible to believe in states following international law even when it's counter to their interests. One of the things that was actually incredibly heartening to see is that following the full-scale invasion of Ukraine by Russia, the Ukrainian authorities were very, very quick to establish a war crimes investigation tribunal that investigated their own people and began prosecuting their own people for violations of the law of armed conflict committed against Russians. Excellent. And were really dedicated to it because their idea was, we are only going to make this work if we believe the law applies to everyone, not just the bad guys. So it is possible to believe in a system that works, you just have to have enough people who do it.
Chris, you agree with that?
Yeah, look, my last comment is going to make me sound like a totally naive optimist, or at least completely naive. You know, I make this comment frequently. In the last 80 years, we have developed, the international system, the United Nations, states, diplomats, a really comprehensive system of law that 80 years ago almost entirely did not exist. The development of law, however, has not been commensurate with the development of mechanisms for implementation and enforcement. And that's the problem. On the one hand, I don't want to get too depressed. You know, the comparison I draw, the common law, English criminal law that we inherited, I think started to emerge around about the 13th century, and it was the 19th century before the bobbies appeared on the streets of London. You know, 8 centuries before there was a police force. It's not going to take us internationally 8 centuries if there is the political will to do it. I'm frustrated as much as anybody, deeply frustrated, but I remain optimistic that this project begun 80 years ago, which is now facing an existential crisis, cannot be abandoned. Cannot be. That we have to work now on making the mechanisms for enforcement and implementation work. And what that requires most is Gareth's line again, good international citizenship at the level of every state.
Yes, and it requires people being informed and knowing how the system works and what they can do to improvement. And I think that a meeting like this probably wouldn't have happened 20, 30 years ago, but now there's greater interest, which is a step forward, so we can all see what we can do to make international law a reality in our lives. All right, well, I'd like to thank our 2 speakers and ask the audience to do so. I'll thank the question organisers. Seem to work not too badly. Thanks. Okay.